Do you know that copyright infringement is a primary concern? When you share materials created by others without their consent, you may be violating their copyright. This includes photos, videos, written content, and any other original work protected by copyright law. My guest today is a legal practitioner here in Nova Scotia, and he will help shed more light into what we should be aware of when we're using social media platforms. It's good to have you in the studio.
Thank you very much.
Right. Before we go on with the business of the day, I'd like you to introduce yourself to our viewers, what you do, and where you're working.
Thank you. My name is Shehu Mustafa. I am a lawyer qualified in Nigeria and qualified in Nova Scotia as well. I work in Dalhousie University as a legal advisor where I advise on a wide range of legal matters.
It's so beautiful to have you in the studio. And like I said before we started, you are the perfect person to deal with this matter. Now, legally speaking, we're talking about copyright here. We're talking about engagement on social media. We'd like you to give us some context to what are the implications when it's not used properly. What should people be aware of when they are doing social media points?
It's a broad range of issues that arise from our use of social media, and I'll try to identify them and touch on them briefly, one after the other. As we lawyers like to say, whatever I say here is not legal advice, it's just information, because in all cases, your specific facts will be relevant in order to understand how the law applies to your situation. Nevertheless, I'll make some general remarks for information purposes. So, one of the first things to consider really in our use of social media is what obligations arise, what obligations do you hold when you use social media? Your obligations are broad. They range from obligations to the owner of the platform that you're using, obligations to the persons you are commenting about, obligations to the persons who own the materials that you are using, obligations to the person that your comments are directed at.
Right.
These obligations include obligations in relation to privacy, obligations in relation to copyright. Some even broach on criminal law. So there's crimes of harassment, for example. There are a couple of cases where consistent sending of emails where the recipient had said, I don't want to receive communication
unsolicited,
from you, unsolicited,
right. Okay.
amount to the crime of harassment in law. Specific to copyright. Now, copyright, let me just backtrack a bit and to say the right to express yourself is a fundamental right under the Canadian Constitution. When you go into the Constitution, you have a primary document called the Charter.
Right.
And the Charter talks about certain rights that are foundational. And the right to expression is one of such. In fact, it's the second in the way the rights are listed. You have the right to conscience and religion. Then you have the right to thought, opinion, expression.
Right.
So the right to express yourself is fundamental and is protected. But like most rights, that right is not absolute.
Right.
Because there's also another right, for example, right to property, right to privacy. Some of those are not so fundamental, but they exist.
Absolutely.
And so in one case, for example, a judge has said your fundamental right to express yourself does not give you the right to defame somebody, for example.
That's right.
Copyright is in the realm of the right of property, in the sense that the creator of any work, literary, artistic, musical work, in which the law confers copyright, has a right to restrict the use of that material that they've created. But there are certain categories of materials that the law recognizes as having copyrights. So if I wrote a book, for example, and it's original to me, the expression of my idea in that book, the law confers copyrights. and you don't even need to register it. The law recognizes my rights. And except for certain limited instances, if somebody else reproduces it without consent,
Right.
it would amount to an infringement of that right protected by law, notwithstanding the person's right of expression.
That's right.
So what the law seeks to do is to create some sort of balance.
Mm-hmm.
On the one hand, the person making the comment or the person sharing or spreading a message has a right to express themselves. But on the other hand, the rights of other people are also implicated. And so the law seeks to strike a balance. And the way this balance is maintained oftentimes is by looking at what was the purpose? Why did this person share this thing? Why did this person express in this manner? And so in the various laws, in the criminal law, for example, the element of intention is always there. Did this person intend to harass? Did this person intend to annoy?
Mm-hmm.
That's the balancing act that the law does in criminal law. In other areas, in the right of privacy, in the area of privacy, for example, the law looks at, did this person have a justification for spreading what should ordinarily be private affairs? Was there even privacy expected in these circumstances? So the law looks at the situation.
Yeah.
And
Now touching on that privacy, I want us to start from there.
okay.
Now, people belong to groups, WhatsApp, or whatever you call it,
Yes.
and they feel whatever we do on this group stays here. And one decides to take maybe screenshots or just literally make a copy of whatever conversation that existed on that platform to somewhere else. And they feel like if you do this, now the privacy of that group has been violated. Let us know how this applies to social media interactions.
Okay.
Is that actually privacy law protected for such a public group or platform?
Thank you very much. Again, your last comment sort of hits the existing tension in the way the law looks at this situation, which is, so social media in itself is almost inherently public.
Right.
And so speaking of privacy in the context of social media is almost like a contradiction, but nonetheless, the law recognizes that the law will look at each case on its specific facts and will look at the nature of the social media that has been identified. Where, for example, you have closed user groups, there are certain groups that are closed in the sense that you need certain access to be granted before you can go into. So although it's a group where there are a number of people which can be said to be public to those members,
Right.
but it's like a closed club. And so if you're not given a gate pass, you can't get into the club. And so some clubs then have their rules.
That's right.
Some social media platforms also have rules. Some of those groups will say we have what they colloquially refer to as Chatham House rules.
All right.
Whatever we say here stays here. Now, those rules of those platforms and those groups are in the nature of contracts,
Okay.
so that every member who joins subscribes to, agrees to be bound by those terms.
That's right.
And once the terms mandate privacy, it then becomes clear that, yes, I may have cracked a certain kind of joke in amongst my family and friends groups, but I didn't intend the whole world to hear about that. And so I had a certain expectation of privacy within that group.
That group, yeah.
And that should be respected unless there justification for breaching that privacy.
Let's go to the legal implication
Yes.
of breaking the privacy
So
in this case.
So, whenever there is such, there are two levels of legal consequences. One legal consequence could be, remember we talked about the group having rules.
Right.
What will be the consequence of disobedience of the group's rules is one legal consequence.
Right.
But a second possible legal consequence could be it depends on the manner in which the breach of the privacy, in quotes, happened. And so if, like I said, there could be justification. If, for example, I feel that certain matters, one usual justification is public interest. Is there a public interest to be protected by dispersing this information beyond this group?
Okay.
And so the law always tries to balance between private interests and public interests.
That's right.
And even in doing that, the law also looks at, okay, even if there was a public interest, the level of dissemination, was it necessary to protect that public interest? So the law will look at, is there a reason, the manner in which it was disseminated. So for example, if I said something in private and you took it and went to show to my employer, I may say, the law may look at it that, did my employer need to know this thing that I talked about in a private closed group? Did it concern my performance of my job? So if it didn't, then the person who went to disclose to my employer may well be liable to me for breaching my privacy, whatever damages I suffer. Because again, oftentimes the law tries to strike a balance. If some wrong has been done, what harm has been suffered is what the law also looks at.
Right.
Yes, because sometimes the law says that there's an expression, a legal maxim, that the law does not concern itself with trifles. So if the harm is negligible, sometimes the law may give a slap on the wrist and say, oh, yes, you were wrong. In law, we sometimes will have what we call nominal damages. Yes, you were wrong, but you didn't suffer any harm.
Right.
So take $10 for, yes.
And just go your way.
Yes, and just go your way. Everybody goes their way.
Yeah, but how about case of defamation for making comments, for sharing materials as well, and someone feels this is hitting on my personality?
Okay.
What are the consequences?
So defamation, I think we'll have to go back. The defamation in social media, through social media, is largely similar to, so online defamation is largely similar to offline defamation, except that the nature of the online ecosystem makes it much more damaging. And so you hear sayings like the internet does not forget. Or one judge has said the online space is a space of perpetual remembrance.
That's right.
And so that's the major difference between online defamation and offline defamation.
That's right.
But for us to even get to defamation, first things first, defamation seeks to protect reputation.
Reputation.
Yes.
Okay.
So that is why one of the fundamental, in fact, the first defense to defamation is what we call, it used to be called justification, but it's really what is called truths. So if somebody says about me, oh, you like to sleep too much, for example, and actually I like to sleep too much, that's not defamation.
Okay.
Because that's the truth.
That's the truth.
Yes.
Okay.
So that's one. Two, so for a comment or for anything to be defamatory, it must be false.
Okay.
Secondly, it must have the effect of lowering the reputation or the estimation of the person in the eyes or in the minds of right-thinking or reasonable members of the society.
Right.
So, I'm a lawyer, for example. Integrity is key for lawyers.
That's
if somebody said to me, you don't tell the truth, I can't take your words.
It's a serious matter.
Yes. If that is not true, it turns out to be false, one, and obviously that would lower me in the eyes of right-thinking members of the society, especially in view of my profession.
And your clients,
yes,
of course.
my clients, exactly. So that will be defamation. So the two elements, there must be, actually 3 elements. There must be some false statements that has the tendency to lower the person commented about in the eyes of right-thinking members of society, and there must be dissemination.
Right.
So that comment must have spread.
Gone round, yeah.
So if you said that to me just in the privacy of this room and nobody else heard, let's say we're not being recorded,
Right.
nobody else heard, that won't be defamation because I'm the only one who has heard it. You can't
That's right.
defame me to me. I know that my reputation, I'm an honest person.
Right.
So if you said that to me just between us,
Yeah.
it's not defamation. But if there is a third person nearby who could have heard within earshot,
Right.
that's defamation.
That's interesting.
Now, in the online space, we say the internet does not forget. So somebody publishes it. Before he knows, somebody else takes a screenshot, and you can't control the journey. It just continues going.
Spreading, yeah.
And so even some of the cases, look at, even when there's been attempt to, so one of the usual remedies for defamation is retraction
Recall.
and an apology.
Okay.
In the online space, recall is almost impossible.
I agree with you.
And so
Yeah.
if you see the cases,
Is that the reason why people have to be very careful?
Oh,
Because
yes.
even when you apologize,
oh yes,
you're not able to
that's
take it
not
back.
enough. You can't take it back.
But are there specific laws regulating social media here in Canada?
So there are laws. For us lawyers, when we say laws, it's a broad thing.
Okay.
There aren't statutes. So statutes are laws made by parliament.
That's
there
right.
aren't statutes. There's defamation acts in various provinces, but none of them specifically addresses social media, as far as I know. Although I didn't check all the provinces, but none of them specifically addresses social media. But there is what we call common law, in the sense that judges have now stretched and interpreted the law to apply to social media situations.
Right.
There's an Ontario case of Clancy against Farid, where Mr. Farid made certain comments about a large number of people who are recruiters in the IT industry, called them all sorts of names, called them dishonest, called them sexual perverts, called them all sorts of names. And the court came down very hard on Mr. Farid because the court said there was no evidence that this thing was true. This statement has been spread so many times. To make Mr. Farid's case worse for himself, he refused to apologize.
Wow.
So the court awarded some heavy amounts as both damages, what we call, so there are different categories of damages. Damages to compensate for the pain and cost to the persons he commented about. Damages to penalize, so punitive damages, and aggravated damages. Aggravated damages being because of the extent of the dissemination.
Right.
Because Mr. Farid kept on repeating the comments.
Wow.
Up to 100 times for some of the people, kept on spreading. So it really meant to damage their reputation.
He went all out for it.
Yes, and the courts came down hard on the defendant in that
Now,
case.
you've talked a lot about consequences. Let's talk to our listeners about that caution that they need to apply when using social media. What are they?
Okay. So, social media is some people use the expression keyboard warriors, and some judges have actually used that expression.
Oh, really?
Yes.
So that's not completely new.
Oh, no. So you hide behind the keyboard, you have a false sense of invincibility.
Right.
Since if you can't see the person, you feel like, oh, I can do whatever I like because the person is not right in front of you. So the usual caution or restraints that some people exercise if they were talking face to face, for some reason, social media seem to lower those inhibitions. And so one needs to be even more careful when using social media. One needs to ask themselves, this thing that I'm sharing, or this thing that I'm even liking, because a like is some sort of an endorsement.
An endorsement.
It's a statement of approval.
Where has that ever happened? Do you have any instance where a thumbs up, for instance, or a smile?
Yes. So I mean, the courts, in law, there's what we call judicial notice. The courts is not a stranger to the developments in society. The courts are aware. The judges are human, one, but also the courts take cognizance of certain prevailing and notorious in the sense of very popular usages that have developed over time in society.
Right.
And so WhatsApp is not new, for example. Emojis are not new. In fact, the first emoji I think came up in maybe 1999 in Japan also.
Right.
So these emojis are sort of use of pictures to communicate. And some people can even have a full conversation in emojis and
That's
they
right.
understand what they're talking about.
That's right.
And so the courts have recognized, the court in Saskatchewan has recognized that where a party sent contractual terms to the other, and the other didn't say a word, but used the thumbs up in response, that thumbs up meant an acceptance, because in law, for you to have a contract, you should have offer and acceptance.
That's right.
So one party made an offer, the other side made a thumbs up, and the court in Saskatchewan said, that's a contract.
Oh.
The thumbs up was an acceptance.
People have to be extra careful.
Yes.
We're going to wrap up, Barrister, and I want to get your thoughts finally. There are also other implications that are beyond the legal perspective, and we're talking about wellness now, mental health. And I know that to some extent, people might suffer some of these damages, as a result of the effect of maybe bullying, cyberbullying, if you like. Your final word. What would you be telling people, again, to be wary of when using social media?
Well, so I would say be careful. Sometimes, even if what is being said is the truth, do you want to get yourself embroiled in the chain of dissemination? Because sometimes people say one truth and then wrap it up in a couple of lies or exaggerations that may not be necessary. So you want to ask yourself before you share anything, before you like anything, do I want to become part of this? Because you own it. And once you like it, you share it, you own it. Saying shared as received is not a disclaimer.
That's right.
It's not a legal disclaimer.
That's right.
And so unless you are saying, I'm sharing this, but I don't agree with it, then the question then arises, why are you sharing it?
When you don't agree with it.
So we need to be sure, again, unless you're asking, okay, I heard this about you.
Can you confirm?
Can you confirm?
Okay.
Maybe that's the instance where it will be justified. But we always need to be mindful and remind ourselves that there are consequences for the things we do. And the fact that it is done online sometimes actually makes the consequences even more grievous than if it were done in person, because sometimes in person, the scope of dissemination is limited to the persons within that realm. So the chain is easier broken, unlike where it's done online, where you don't know where it can go.
Exactly. Wow. That has been an explosive moment of learning these things. Some of us have been on social media for the longest, and I didn't even realize that there are consequences with the things we do. Thank you so much for giving us your perspective on all of this. Really appreciate your time. Within that short notice, you showed up here.
Well, thank you. It's my pleasure. Always a pleasure to be able to give back to the community.
Indeed. All right. So that was Shehu Mustafa, a legal practitioner here in Nova Scotia. He's been talking to us about the legal implication of using social media. Don't forget to subscribe to this channel for more information such as this one. I am Promise Okoy, and I will see you soon.